oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-7130. Westinghouse Electric Company, LLC, appellant versus Korea Electric Power Corp. and Korea Hydro and Nuclear Power Co. Limited. Mr. Krasik for the appellant, Mr. Davidson for the appellate.
Good morning, counsel.
Morning.
Mr. Krasik, please proceed when you're ready.
Thank you. May it please the court, I'd like to reserve 2 minutes of my time for rebuttal. The district court in this case erred by imposing requirements on Westinghouse's declaratory judgment action not found in the text of the Declaratory Judgment Act. Having established the district court's subject matter jurisdiction over this case and Westinghouse's Article 3 standing, nothing more was required to invoke the Declaratory Judgment Act. In particular, Westinghouse had no need to show that Part A10 may be enforced by a private right of action. This case involves what has been referred to in the parties' briefs as a defensive declaratory judgment.
Before you get to the statute, can we talk about standing?
Sure.
So you need for the declaratory action to support resolution of some other concrete Article 3 case or controversy, right?
I think we need to demonstrate a ripe and justiciable controversy and then the 3 elements of Article 3
Yes,
standing.
but a legal dispute about some statute or regulation in the air
Correct.
with no threat of enforcement does not create Article 3 standing.
Well, if there was no threat of enforcement, I would agree with you, but here there's been threat of enforcement. In fact, the Department of Energy has specifically advised Westinghouse.
Department of Energy is not the declaratory judgment defendant here. They're not going to be bound by our judgment as between you and the Korean entity.
That's correct, because Westinghouse has no adverse dispute with the Department of Energy. Westinghouse doesn't dispute Department of Energy's interpretation of Part
No
A10.
dispute, and we couldn't redress any controversy with
Well,
non-party.
I would not agree with that part of your question, Your Honor, because the dispute is with the appellees and the appellee's conduct under this unique structure.
Right. So one possible theory of standing would be that the declaratory action will help resolve the contract dispute with the Korean entity.
I wouldn't
And that just runs right into the arbitration.
Right. And I was going to say, I don't agree with characterizing it as resolving the contract dispute. I would
Okay, then it might be in service of resolving a freestanding dispute under the regulation.
Correct. And that's the way we view
And
this.
that seems to run right into the express limitation on injunctive actions to the Attorney General. The AG has to be that plaintiff.
Well, if I could answer that question in 2 ways, Your Honor. First of all, we don't believe it does in the sense that the injury here is not redressable because, first of all, we assume that the appellees would comply with whatever interpretation of Part A10 was given by the district court. And if they didn't, then there would be an authoritative interpretation of Part A10 by a U.S. court that could then be used to support a claim for breach in the party's contract dispute. However, that's not the purpose of this declaratory judgment action. This declaratory judgment action is to prevent.
So does that second route come into play at all in your view? The second route being that it would be something that could be used in a contract dispute.
We don't believe it will be necessary because
Okay,
we believe that the appellees will comply with the interpretation of Part A10.
So for your purposes, we discount that second route.
Correct.
That's not relevant to the case.
Correct.
It's in theory a chain of events that could happen, but we don't consider that for purposes of standing.
Correct.
Your view is that what we consider for purposes of standing is the first route that you.
It is in the sense that we believe that having an authoritative interpretation of Part A10 by a court, a U.S. court with experience in interpreting U.S. regulations in and of itself is redressability. However, if there needs to be some other element of redressability, the second prong of a potential use of the judgment in future litigation would be another form of redressability. In fact, in one of the cases we cited in our brief, Judge Scalia.
That framing, the chief's framing, is exactly how the district court viewed the case, right? You're not pushing a contract claim, so we'll just conceive of this as something under the reg.
I agree with that, Your Honor. But
okay, but then when you were pushed a little bit on Article 3 standing in red brief, you came back on reply and said, no, this will have preclusive effect in Korea, citing the Korean rules of civil procedure.
right,
So you're sort of, shifting.
No, I wouldn't. I don't see it that way, Your Honor. As I said, we believe there's redressability simply by an authoritative interpretation of Part A10 and alleviating the threat of DOE enforcement. However, as a second prong of redressability or down the road redressability, there could be preclusive effect to the judgment in the party's arbitration proceeding. And what I started to say is that in one of the cases cited in our brief, Judge Scalia's opinion in Metamune v. Genentech, there was specifically discussion of the use of a ruling on an affirmative defense in potential future litigation between the parties, although there was no pending litigation or even contemplated litigation between the parties at that time. So the Supreme Court has recognized the potential use of a ruling in future litigation to satisfy Article 3 standing and redressability for purposes of application of the Declaratory Judgment Act.
So
Yeah, I mean, I agree with that. You can solve your standing. You can solve my standing concern by pointing to use of the declaratory judgment in the Korean arbitration. That just creates a different problem for you. And why is it appropriate to use the Declaratory Judgment Act to end run an arbitration clause?
Well, I wouldn't describe it that way. I don't see the two remedies as mutually exclusive. We have the right, we believe, under the Declaratory Judgment Act to seek a declaration as to the interpretation, the proper interpretation of Part A10 in a U.S. court. There is a ripe and justiciable controversy between the parties as to the interpretation of Part A10. The DOE has advised Westinghouse that it will be held responsible for compliance with Part A10 with respect to any retransfer of Westinghouse technology by the appellees, and the appellees have refused to provide the information that Westinghouse requires to comply with Part A10. And that refusal places Westinghouse independently at risk of enforcement action by the DOE through no fault of its own. It is specifically to alleviate that threat that Westinghouse has brought this action completely independently.
So on the theory that you have, which is take the arbitration out of play altogether, because even if it's a sequence of events that could come to fruition, it's not germane for us for purposes of standing. For purposes of establishing your standing, you're not relying on the theory, and you couldn't because you said below
Yes,
that you don't want to deal with the arbitration clause.
correct.
So you want to put the contract out of the field of vision. So you're
Correct.
only relying on the first route. On the first route, what happens? So the declaratory judgment is your theory that 810 compels the other side to turn over information to you
Yes.
of its own force. It does. The statute.
The reg.
The
reg. Sorry.
Yes, that because of the unique structure of Part A10, there is an obligation on the appellees to provide the information that Westinghouse requires to not be found in violation, particularly when appellees are the only source of that information. Only appellees.
Is your view that if you prevail, if you have standing and you ultimately prevail in the declaratory judgment action, that then the other side, as a consequence of the judgment, has to give you the information?
It's an interpretation. It's not an injunction. We've obviously not appealed the dismissal of the injunction. And under the Declaratory Judgment Act, it's simply an interpretation. But that is a right that we believe the Declaratory Judgment Act provides. And as I said, we assume that they will comply with that interpretation. If they don't, then there would be a claim for breach down the road. But that's not where we are today. I see my time is short.
Can I
I'm
ask
happy to
you-
answer. Sure.
I'd like to ask you how you read 810.2D. It seems to give you an out. Persons under U.S. jurisdiction are responsible for their foreign licensees, contractors, or subsidiaries. And then it says to the extent that the former, which is you, have control over the activities of the latter, which is Korea.
Yes.
How do you read that?
Yes, and I know that Appleese cited that provision in their brief. We don't believe that that's the relevant predicate for this lawsuit. As was alleged in our complaint, Westinghouse has been specifically advised by the Department of Energy that it holds Westinghouse responsible under Part 810, subject to criminal and civil penalties for Appleese retransfer of Westinghouse technology to a third party. So it's not 810.2 that really comes into play here. It's the allegation, which obviously must be taken as true at this stage of the proceeding, that the Department of Energy has said it will hold and does hold Westinghouse responsible under Part 810 for compliance.
Why
Can I
did
ask
you-
one other question? That is, are you at all regulated by the IAEA, or do they just regulate countries?
I don't know the answer to that question, so I don't want to misinform you. This action only arises under the Atomic Energy Act and the Part 810 promulgated thereunder.
Why did you not appeal the claims for injunctive relief? One classic use of a declaratory action is in support of an injunctive claim, just with a lighter touch.
The reason is that while that scenario you just posited would be true, that to us potentially runs afoul of the lack of private right of action issue. So in effect, we realize that including the phrase injunctive relief in the complaint was probably overreaching in terms of the application of the Declaratory Judgment Act. And because it was dismissed, we weren't appealing that dismissal because all we're applying here is the Declaratory Judgment Act and its interpretation remedy without coercive action.
So an injunctive action to enforce 810, your reading of 810 against the Korean entities might be, assume I think that would be an action for any violation of the statute or the regs under the statute.
I think that's fair.
Why would a declaratory action to establish exactly the same legal predicate, which is a violation of regs under the Atomic Energy Act, why would that not be an action for any violation of the statute or the regs?
Your Honor, because I don't see the remedy as you've described it. It's interpreting the disputed obligations under the Act. It's not finding a violation of the Act. Westinghouse has one interpretation.
Sure it is. The whole point of your declaratory action is to establish that the retransfer by the Korean entities without further licensing or disclosure or whatever would violate the regs. That's the whole point.
I would frame it that the Appleese failure to provide the information Westinghouse requires to comply with Part 810, we believe to put Westinghouse in jeopardy of violation of the regs. But we aren't seeking to enforce Part 810 against Appleese. And the other point I was going to make to Your Honor's question is that the scenario you posited of injunctive relief coupled with the declaratory judgment is the scenario and the pattern of all, except for the one Second Circuit case, which just failed for lack of Article 3 standing, but all of the other Court of Appeals cases that were cited in the Appleese briefs, it involves substantive claims for relief with a companion or ancillary request for declaratory judgment. It's no surprise there that in dismissing the substantive claims for relief, those courts also found that there could be no declaratory judgment relief because it's well established that the Declaratory Judgment Act provides no federal jurisdiction or any substantive rights not otherwise provided. So those cases are simply consistent with the general principles but don't touch the issue of whether a private right of action is required.
Okay, thank you. We'll
Thank
give you a
you.
little time for rebuttal.
Thank
you. Mr. Davidson?
Yes, thank you. Good morning. May it please the court, Stephen Davidson on behalf of the defendants appellees. Our position in this case is, we believe, simple and clear, that the case begins and ends with the statute. The statute 2271C, as your honors are keenly aware, says no action shall be brought against any individual person for a violation of this chapter unless and until the Attorney General of the United States has advised the commission. And no such action shall be commenced except by the Attorney General of the United States. So to us, this statute provides the answers to the questions that have been presented to this court on appeal.
Can I just start you off by asking, so you heard the exchange earlier,
Right.
and there were two conceptually possible routes for standing that were outlined, the second one of which was taken off the table because they're not relying on the agreement. Do you agree that under the first route, there is standing and redressability in particular?
If I remember which route is which, but we raised this issue, as you know, in our brief, and our view on this is that to the extent they're not seeking to enforce a violation, there's no standing. And to the extent they're seeking an interpretation, that's barred by the bar on a private right of action under the statute. So there might be standing if they say they're not seeking an injunction, but there's no ability to proceed with such a case for the reasons we've set forth in our brief.
On the merits, not as a matter of redressability, but just that.
Well, as a matter on the merits in the sense that there's no private right of action and the Declaratory Judgment Act doesn't solve their problem.
Right, which the presence or absence of a private right of action is a question for the merits question.
Right.
Under steel company. So you think that under the route that's been outlined, they might get past the Article 3 threshold, but then they ultimately lose on because under your view, the district court's view, there's not a private right of action.
Correct. And we raised that issue in our brief because the Westinghouse seems to be vacillating a bit on which ground it's going on. So we wanted to be clear that there's one that doesn't give them standing and one that does give them standing but doesn't give them any relief. And we believe it's clear under this statute that there's no private right of action. On the face of it, just the face of the words of the statute make that clear. And to the extent the court wishes to go into whether there's an implied right of action, we believe that is clear as well. There have been 3 circuit courts have decided this question on whether there's an implied right of action under the Atomic Energy Act and have all said no. There are a number of district courts who reached the same conclusion. They rely on one case, a district court case from 1978, which predates the other circuit court's decisions and predates the more recent jurisprudence on implying a private right of action from the Supreme Court in Sandoval and from this court in various decisions. And with respect to the Declaratory Judgment Act, we would say that following the teachings of Schilling, that it has to be a judicially remediable right, that this court and a variety of other circuits have made clear that that has to be a cause of action. And we would particularly rely on the Ali decision and the cases that have followed it in other jurisdictions. The Netflix case from the Ninth Circuit has what we think is a very apt quote in which it says, "We agree with our sister circuits that the Declaratory Judgment Act does not provide an affirmative cause of action when none otherwise exists." And they cite the 2nd, 3rd, 5th, 6th, 7th, 9th, and rely in particular on the Ali decision to reach that decision. And the appellants rely again on a district court case saying that that's not so, but in that own district court's circuit, the 7th Circuit in the alarm detection system case, made quite clear that a cause of action is required. The alarm detection system court decision, which came out after the case they rely on, says, judicially remediable right means this cannot be pursued without a predicate right of action. And we think because of the language of the statute, because there's no implied private right of action, and the Declaratory Judgment Act gives them no relief, and in particular, their forsaking of reliance on the contract, because obviously it has an arbitration clause. And as you've seen from the record, the arbitration is going forward. So there is a live dispute between these parties in which many of the issues raised by them are being litigated in an arbitration in Korea, there's no basis for this case to go forward. And the policy arguments made by Westinghouse and the amicus, we think fall flat for two reasons. One, there is no basis to proceed on a private right of action, and Congress has made that clear. And the teachings of this court from the Johnson case make clear that private rights of action are disfavored, implied private rights of actions are disfavored, and if there's an issue as to whether there should have been one, the issue is with Congress, not with the courts. And otherwise, we rely on the arguments in our brief. Thank you.
My colleagues don't have questions for you. Thank you.
I do
Oh.
have one question.
Oop.
That is,
Thought I'd get away.
what is before the arbitrator? I mean, he can't or she can't say, no, you don't have to comply with the Atomic Energy Act.
Well, there are claims and counterclaims in the arbitration. Our clients filed the arbitration against Westinghouse, and Westinghouse filed a counterclaim. And in the counterclaim, Westinghouse is seeking relief under the License Act, the license agreement, claiming that our clients are in breach and saying that the regulations apply to our conduct. The regulations, I mean, the 810 regulations apply. Thank you.
Thank you. Mr. Krasak, we'll give you the 2 minutes you asked for rebuttal.
Thank you, Your Honor. Just want to address a couple points relating to the judicially remediable right point that Appley's counsel raised. Appley's counsel specifically relied on the Netflix case from the Ninth Circuit as allegedly supporting his position regarding the requirement of an independent cause of action. The Netflix case, which he didn't mention, also specifically says that that is for what's been described as an offensive declaratory judgment, but for a defensive declaratory judgment, that is not required. And that is specifically what's being brought here, very analogous to the Supreme Court's decision in MedImmune v. Gentech, where the Supreme Court noted that when threatened action of government is concerned, we do not require a plaintiff to expose himself to liability before bringing suit to challenge the basis for the threat. In that case, the issue was an affirmative defense of invalidity of a patent, which provided no cause of action. In fact, Justice Thomas, in his dissent, criticized Justice Scalia in the majority for allowing the case to proceed when there was no cause of action. But the Supreme Court majority opinion was you could bring a defensive declaratory judgment with no independent cause of action.
Suppose we agree with you that there's what's required is a judicially remediable right, emphasis on right, and not a cause of action. What is the right you're seeking to enforce? This case is all about your legal obligations under the statute and the regs. So it seems to me, you're conceptualizing the DJ Act sort of like a 1983. It gives you the cause of action part, but you need to point to some other rights creating language. But even on that theory, what right are you suing to enforce?
Right. We believe that judicially remediable right, as contemplated in Schilling, means a right that can be vindicated in federal court. And that's clear from the decision in Schilling, which involved a judicially unreviewable administrative scheme that effectively lacked Article III standing. And the court went on to say that without that, you did not have a judicially remediable right.
Right just means interpretation of some
Article III standing, and
includes your duties as well as your.
Yes, exactly.
Okay.
Exactly. I guess my time is up. Thank you.
Thank you. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 23-1347. Food Marketplace, Inc. et al. Petitioners versus Environmental Protection Agency and Michael S. Reagan in his official capacity as Administrator, United States Environmental Protection Agency. Mr. Lin for the petitioners, Mr. Martin for the respondents.
Good morning, council. Mr. Lin, please proceed when you're ready.
Good morning, Mr. Chief Judge, and may it please the court. Albert Lin on behalf of the Petitioner Food Industry Associations. And if I may, I'd like to reserve 3 minutes for rebuttal. The associations fully support the policies behind the AIM Act, and there is much in the rule that we do not challenge. But the aggressive deadlines EPA has set for the refrigeration and HVAC sectors make compliance virtually impossible, which is a reflection of the fact that several key premises are legally wrong or unexplained. I'd like to focus on 3 this morning. The first is that EPA's interpretation of the term availability is inconsistent with the plain meaning of that word. Rather than ready to use, EPA's interpretation is more like maybe possibly ready. EPA now says it agrees with that definition, but that's not what it said in the rule. The second error is a failure to explain under the Supreme Court's recent Ohio versus EPA decision. Just as in Ohio, EPA here promulgated a rule premised on certain assumptions being true. In Ohio, it was the number and identity of states. Here, it is the number of and identity of substitutes. Ohio holds that even accepting those assumptions and predictions are adequately explained, an agency must anticipate and address what would happen in the event that certain of those assumptions don't pan out in reality. EPA did not do so in Ohio, and it did not do so here. And finally, our third issue is that if you actually dig into them, some of EPA's predictions in every subsector are underexplained. And that is an independent problem that undermines the rule under the Maryland, DC, Delaware broadcasters case.
Let's start with your legal point.
Yes, Your Honor.
I'm just very puzzled at what the dispute actually is at this point. I can imagine a focused legal argument about whether availability is assessed at the time of compliance or at some earlier point that gives you lead time. I can imagine a focused legal dispute about whether all or some of the sub-factors must be satisfied. You gave up both those arguments. You affirmatively gave up both of those in your reply brief. You invoke a dictionary definition of plain meaning, which EPA doesn't really contest. So what are we fighting about at this point on the interpretive question?
Of course, Your Honor. So 2 answers. I thought you were going in a different direction. Let me start with where I think you ended, which is that EPA doesn't contest that the plain meaning is ready to use. I think the problem for them is that that's not what they said in the rule. They said in the rule that
Present or ready for immediate use at the compliance date.
correct.
Okay.
Yes. And that's not what they said in the rule. What they said in the rule is that they understood availability based on, they considered substitutes available based on the expectation that many of the sub-factors could feasibly be met. We don't think that that is the same thing as ready to use, Your Honor. I think you will search in vain in the rule for the phrase ready to use, or Judge Katsas, as you said, immediately available, immediately obtainable at the time of compliance. They don't say that.
So you're fussing over the wiggle room introduced by the word expects, the word many, and the word feasibly.
Could feasibly. Could I give you an example as to why? Here's why I think it matters. I think it's one thing if I were to predict, Your Honor, because the definition of availability is what they're making their predictions against, right? So if I were to say, Your Honor, I think you will win this race against this Olympic champion, there's a certain number of things that you would expect me to say to justify that. I think it would be actually perhaps impossible for me to rationally justify it. But if I said you could feasibly win this race against an Olympic champion, or you may possibly win this race, there's a lot of other explanations that I could provide, including that I think it's possible that the Olympic champion would trip and fall and you would finish first. That's why the distinction matters. Ready for use at the time of compliance requires more explanation or qualitatively different kind of explanation than does what they said in the rule.
So expects just connote, to my ear, expects just connotes the truism that if the relevant time for assessing this is the effective date of the rule, by definition, they're making a predictive judgment.
Of course, Your Honor.
You can't observe a fact about the world. So
Correct.
prediction is an expectation.
Correct.
That seems,
Yes,
a
we are not,
truism.
we're not taking issue with the word expects.
all right, many sub-factors is just the question I pointed out earlier that you affirmatively gave up. You could fight over whether some of the sub-factors are necessary elements. You've given that up. So the many doesn't really help you. So we're just fighting over gradations connoted by the word feasibly?
And the word could.
Could feasibly.
I think could feasibly, again, encapsulates an indeterminacy that is very different from will be ready for use at the time of compliance. And again, I think hopefully my example was helpful to you. We can come up with other ones if we would like, but I think there is a difference between predicting that something with certainty, and I think ready for use encapsulates 100% or something very close to 100% certainty. And again, right, that's not saying that a prediction will necessarily come true, and that raises an Ohio versus EPA problem. But the issue here is that the backdrop against which they're making their predictions, which then sets the how you do the arbitrary and capricious review, right? What you expect of them to say is fundamentally wrong, and I think there's a material difference there. So that's the first point, is the word availability, and I think it is particularly telling, Your Honor, that my friend in his brief doesn't even attempt to defend could feasibly be met. He doesn't cite it, he doesn't talk about it, he doesn't try to distinguish it, he just says, I agree that ready for use is the meaning. And so I think on that ground, because that affects everything else that follows, this court could vacate the deadlines that we have
So,
challenged.
can I just ask you that there's a strict preservation requirement in the statute for this interpretive question? Was that put before the agency?
Your Honor, this specific argument was not raised, and I want to be candid with you about that. But I do think for two reasons. One, I think under the Appalachian Power case that the Supreme Court just talked favorably about in Ohio, the agency was aware of this issue and did address it, talks about it, spends several paragraphs defending it. But I think perhaps more importantly, this issue falls squarely within this court's key assumption doctrine. An AF&PM case that we cite in our reply brief says statutory interpretation questions that go to the foundational existence of the rule or pertain to the analytical methodology, I think are part of the agency's affirmative obligation to undertake non-arbitrary and non-capricious rulemaking. And I think both of those factors apply here.
As to the delta between what they talked about in the proposed rule and what you think the deficiency is, you think that's a foundational assumption?
I think the meaning of availability, Your Honor, is a statutory interpretation that is foundational to the rule. I think the meaning of availability is a question that pertains to the analytical methodology for the very reasons that we just discussed, which is that it guides and controls what evidence and what rational connection they need to articulate. I think both of those reasons apply here.
Do you think any dispute about the meaning of a substantive term fall within this, what's it called, fundamental assumptions doctrine?
I think this court has held that that's not the case. Again, I think
right, because otherwise you would say that no statutory claim can be forfeited, which
Correct.
seems
correct, Your Honor. And there is a case.
So then we're just trying to assess, like a junior varsity major question. Is this statutory dispute sufficiently important, foundational, basic? Or is it something more on the margins?
No, Your Honor, I don't think it's sort of like a squishy sliding scale, because I think the AFPM case is trying to articulate categories of statutory interpretation questions, things that go to the core statutory authority as opposed to the example in the AFM-PM case was there was a statutory interpretation question about the meaning of the Regulatory Flexibility Act. And the court says that I think it was the AFM-PM case, and I apologize if I have that wrong, but they say that's not a statutory interpretation question that goes to the sort of the agency's authority to act. So I think the case is trying to create some categories. One of them is that. The other is, again, statutory interpretation questions that pertain to the analytical methodology. Again, I don't think that that's you know it when you see it.
My reaction, as you can probably guess from my questions, is doing a great job trying to crystallize a legal question, but it's gradations of could feasibly versus will be. Doesn't strike me as the most foundation.
I understand, Your Honor. We think that it does. We think that it goes right to the core of how they do the analysis here, which I think falls within one of the categories of AFM-PM. But if I could, I'd move on to the second point.
Can I just give one clarification on this first one, and then we'll go on the second one? So I take it that in response to the questions that we both asked, Judge Katsas and I have asked, your view is that availability val non is a foundational question. The fact that the remaining dispute might be a fairly narrow one about what was wrong with what the agency did versus what you think they should have done. The narrowness of that doesn't matter for purposes of key assumptions, because the key assumption is just availability, period. And then once you're in the availability realm, then it doesn't matter how narrow the dispute is. It's still a key assumption. Is that the way you're?
Yeah. Okay. Yes, Your Honor. I think that's logically makes sense. I mean, for example, I think if you had a statute that gave EPA the authority to regulate greenhouse gases, right? And there's a dispute over what the meaning of the phrase greenhouse gases is. The key assumption doctrine applies because that's a question of statutory interpretation that is about a word that is at the foundation of the agency's authority to act. That dispute may be narrow. What the substance of the dispute is, I think, is different from whether the question of statutory interpretation is foundational. The second issue that I'd like to highlight is I think there is a failure to explain under Ohio versus EPA. And as I previewed at the outset, and as this court I think knows, in that case, the Supreme Court said in granting the stay that EPA failed to address an important part of the problem where it built a rule on certain assumptions.
Sorry, you're transitioning to the second of
Yes.
the three that you introduced.
That's right.
So maybe I misheard you. Did you have a second reason why we might excuse any forfeiture? Or you're just you're resting on the key assumption doctrine?
Oh, the second reason, well, I think I said the Appalachian Power case of this court says that the purpose of 307D7 is to ensure that the agency has had an opportunity to express, apply its expertise. And we think that it did so here. Again, if you look at the rule, it addresses this question.
Okay.
On Ohio versus EPA, again, that the court said that when an agency builds a rule on certain presumptions, and there was the presence and identity of 23 states, that they has to anticipate and explain what happens if something falls away. Again, not necessarily if in fact, although that ended up being true there. But the question is, as you look forward, you have to figure out, you have to explain, what do you do if one of these assumptions doesn't play out to be true? And here, the assumptions and the predicates are for the various subsectors, the availability of a certain number of substitutes, 6 for some, 11 for others, 10 for some of the other ones. There is no explanation here as to what happens if one of those substitutes falls away.
So there's a logical upshot of that view. So suppose that there's 25 substitutes and 24 of them cover 99% of the situations and one of them just covers one. And if just that one has a kink in it, has a chink in it, then unless the agency spells out that if that one, even if that one goes away, we still reach the same conclusion, they've got to start over.
That's an explanation, Your Honor, that they could have provided in the rule. And I think that's what Ohio stands for. I mean, if you look at the Ohio case, what Justice Gorsuch says there is, perhaps there is some explanation why the number and identity of participating states does not affect the ultimate conclusion. That's our point here, is that perhaps, Your Honor, the 25 doesn't matter. And perhaps it's because 24 of them or cover a lot of it, perhaps the number doesn't matter at all, right? Which is what the dispute was between the majority and the dissent in Ohio, that we didn't really mean this number to be foundational or important, right? But again, as Justice Gorsuch says there, that's an explanation that the agency could have and should have provided in the rule, but it didn't. And that is a failure to address an important aspect of
I
the
thought
problem.
Ohio turned on the fact that the agency's own explanation there assumed that, I may get the fact wrong, but they said all 23 upwind states would do such and such. And the court found that wasn't justified.
I see my time has expired, but
Just seems very different from what's
yeah.
going on here.
well, I don't think so, Your Honor, because I think that's what justice, you could tell that
That's a core part of the court viewed that as an essential element of the explanation, right? Whereas here, the point of this scheme, nobody cares whether a supermarket is using substitute 7 or substitute 8. What they care about is that the supermarket is no longer using CFCs or HFCs.
I think we're sort of on the same page about Ohio, but let me start there and then move to the application of it to this case. I think what the court in Ohio said is, we think, but we're not sure. And I think that's an important piece of it. I think the court said, we think, but we're not sure that what you've built here is a Jenga tower. And you haven't explained what happens if some of those pieces get pulled out. Maybe they will be, maybe they won't be. But then in addressing, to make very clear, I think that we think, but we're not sure, in addressing Justice Barrett's dissent, there's a whole discussion there about, is it in fact a Jenga tower? Which I think goes a little bit to your question of how we understand Ohio. I think the court says, look, the dissent says it's not a Jenga tower. It's something else, right? It's not built on these 23. And Justice Gorsuch says, maybe, right? But we're not sure. We think it is. There's signs in the rule that suggest that this is a Jenga tower. And you have to explain either one, what happens if you pull some of those pieces out, or two, you can quarrel with whether it's a Jenga tower at all. So that brings us to our case. I don't think it's just about, do they use one substitute or another? The agency says in a number of places that a variety of substitutes is important, right? More than one. That we identified multiple substitutes to ensure a smooth transition. That's in the rule. And so I think the fact that they have 6 or 11 is important. And I think, Your Honor, if you look at the Maryland, DC, Delaware Broadcasters case, where Judge Ginsburg wrote the majority there, and he said that one was about where there are 2 compliance options for FCC, and one of them was unconstitutional. And what he says there is, presumably,
which are sort of related, which both are pressuring the broadcasting companies to do something unconstitutional. It just seems very different.
But again, Your Honor, I think that's something that the agency could have said. I think that that's what Ohio was saying. They can provide an explanation for why the 6 is not an important number.
So if they have 12 substitutes as possibilities, do they have to go through and explain every single permutation? Like if number 7 is out, but 1 through 6 and 8 through 12 are in, we'd still do this. If 7 and 2 are out, 3's a maybe, 5's a probably, and 8's a very likely but not sure, here's the result. Do they actually have to go through every single permutation?
Your Honor, I think that's the same question that one could ask of what the Supreme Court was expecting of EPA in Ohio, which is, do they have to go through every permutation of the 23 states?
The way you described Ohio, you said, we think, but we're not sure it's a Jenga tower. Suppose that the assumption is the opposite, that we're pretty sure, but they didn't explicitly say it, but we're pretty sure it's not a Jenga tower. Does it still, at that point, still vacate and send it back for the agency to say, no, your assumption was right, it's not a Jenga tower?
Your Honor, I think what Ohio reflects there is that there's some play in the joints there. I would say that if you're in that middle where you say, we think, but we're not sure, we think it's not, but we're not sure it isn't, I think they still have to provide the explanation. Your Honor, if you look at the rule, you disagree with us and you say, this is absolutely not a Jenga tower, well, then we've got a different case. But I think that there's a lot of language in the rule where EPA says it, this is in the technical support document. We accounted for the fact that not every substitute could be used in every application, but by allowing a range of substitutes. The fact that there are multiple substitutes is critical to the deadlines that they picked. And more importantly, and I realize in Maryland, Delaware, DC, or DC, Delaware, there were only 2, but I think there's something to be said for the fact that, for some they said 11, for some they said 12, for some they said 6. Why that number? Again, the burden is on EPA to explain that.
Let me give you a couple of conceptual reasons why I'm resistant to your maximalist, or at least aggressive reading of those 2 cases. One is the EPA rule of prejudicial error. Right? It's your burden to show that any mistake in reasoning made a difference, or could have made a difference. It's not a harmless error. It's not like you show error and then they have to prove harmlessness. It's not Chapman or something. It's first point. Second point, there's kind of a loose analogy to severability here. I don't think this is really severability because the options are in the support document rather than the codified text. But if you think about it that way, the presumption is in favor of severability. If we can just excise one of the options and the rest of the scheme doesn't just collapse, the presumption is that we do that. So you're saying, unless it's their burden to show severability rather than your burden to show inseverability. And both of those ideas leads me to think, as long as some number of these options remain, it's not good enough for you to just knock out 1 or 2 here or there.
If I could take those in turn, and then I think there was a third one there about what if we actually do show that some of them are out. So on the first question of the APA doctrine of sort of prejudicial error, I think Ohio actually speaks to that, Your Honor, at the very end of that opinion, where Justice Gorsuch is sparring with the dissent. He says that the dissent says this might be harmless error. And he says, 1, they didn't raise it, which is the same here. That harmless error argument has not been raised. And the second is, this under the Clean Air Act, 307D9, he says, there might not actually be, he says the prejudicial error language in the Clean Air Act, which is slightly different from the APA, is in 307D8, which talks about procedural determinations, and not in 307D9, which sets forth arbitrary and capricious and exceeds statutory authority. It sort of mirrors the standards. So that's answer 1. I think Ohio
Find all
answers
that in the middle.
Yes, the very last before the star. The second, to your severability point, again, I think Maryland, DC, Delaware answers that. I mean, that is a severability case, and it says that if they haven't provided that explanation, and there's been a lot of skepticism recently by the Supreme Court and other courts about, severability clauses that just from the EPA that just sort of say, well, all of this stuff is severable and can stand alone if you find an error. And I think that case, I don't think it's a maximalist reading of it. The third question that you had asked is about whether some of these, and I'm way over my time, I understand, but if some of these fall away, what happens to the rule? And I just want to say, that gets into the third point that I wanted to raise, which is, so there's availability, there's Ohio, which assumes that the predictions are adequately explained. But then there's the third piece of this, which is we actually don't think some of the predictions are adequately explained. And I don't want to abuse the court's privilege here, but the main complaint that we have is with their analysis of building codes, and particularly with respect to local building codes. They have some answers to statewide building codes, which we don't think are sufficient. But for local building codes, really the only thing that they say is there are 30 states, and that number we had trouble finding in the record, but they say there are 30 states in which SNAP-approved substitutes must be allowed by local building codes. they provide no answer to the other 20, other than the hope and the prayer that those local ones are going to come around. And I know they say, and we don't contest, that they don't have to go locality by locality and show every single one. But the localities in 20 out of 50 states is a lot. And I think that the arbitrary and capricious standard requires the fact that they have to provide a rational connection, requires them to do something, to say something about what's going to happen in those localities.
You don't dispute they can construe availability to mean generally available.
I don't. I think that's consistent with the idea that we
So,
don't
I
think they
mean-
have to go through every locality.
I don't know, the map that they cite seems to show that we're somewhere north of 40 states that have approved or will have approved at least the A2Ls
At the state level,
in
Your Honor.
light of the double whammy of the SNAP approval and the IBC approval. Seem like they're pretty powerful.
But I think I think it's important to distinguish there. I mean, that map is only talking about statewide legislation. It's not telling you which states have statewide legislation that preempts local laws. And that for us is the really big problem here. Is that they have some answers at the statewide level. And again, I don't think that they explain why the 2 additional years or the 1 additional year actually makes any more sense than 4 or 5. But for the localities, that map it doesn't answer that. That's not talking about states where you have statewide laws, state law that preempts localities from doing something different.
Sorry, I thought they're showing like the light blue states say building code legislation signed into law.
Correct.
I assume that means that the state has said
It does not,
it
Your
is
Honor.
permissible to use an A2L refrigerant.
That is not what it
Okay,
means.
what
It does
mean?
it adopts it as the state's standard, but they admit that because of home rule, the localities can do something different.
Can impose a higher
Correct.
standard.
Correct, Your Honor.
Despite the state approval.
That is absolutely true. That's in the rule and they admit it. They say that in many of these states, this is JA 39, 73, I have an extra number here. I think it's 143. Many states allow local governments to set their own building codes provided they comply with the minimum standards established, minimum standards of safety, right? So they don't have to, that map doesn't address.
Unless there's preemption.
Unless there's preemption.
Which can happen.
And they say that there's 30 states. Again, I don't know where that is in the record. It's not in that map. They cite to a blog, I think, a blog post that I pulled up, doesn't have the number 30 in there. But let's take their 30. They don't explain what you do in the other 20. They don't say, well, we think localities generally come around at a clip of 75%, so it's going to be fine. There's no explanation for the other 20. Your Honor, that map has a lot of different colors on it, but it doesn't address the local home rule problem. And with that, Your Honor, thank you for the additional time.
We give you a little time for rebuttal. Mr. Martin.
Morning, Your Honors. May it please the court, Daniel Martin for the United States. With me on the brief and a council table today is Keqiang from the Environmental Protection Agency. So, Your Honors, after hearing the presentation from my friend on the other side, I want to begin today by focusing on where petitioners agree with EPA. They agree that Congress instructed EPA to promulgate technology transitions rules by, in the words of the statute, factoring in, to the extent practicable, the availability of substitutes based on best available data. They agree that the sale only concerns prospective application, meaning sale or installation of equipment, new equipment, building new supermarkets in the future. There's no retrofit requirement. There's no, you have to go tear out your old HFC using systems and put in these new systems. And they agree that because these compliance deadlines all take place years in the future, that we're inherently talking about a predictive judgment about whether a substitute will be ready for use in the future based on EPA's professional judgment and the factors that Congress set forth. So with that agreement in mind, we're really dealing with a narrow question today for just these 5 specific subsectors These are all severable from each other. Both petitioners say that, EPA said that in the rule. They're all supported by separate analysis. For just these 5 specific subsectors, are these compliance deadlines reasonable? And the number thing I want to convey to the court today is that's an arbitrary and capricious question, not a statutory interpretation question. Because we're in a situation where Congress says, here is what we want you to do. Here are the factors that we want you to look at. Again, factor in to the extent practicable. So go do fact finding, go examine these factors, apply the best available data, your professional judgment, and reach a reasoned conclusion. And that is arbitrary and capricious review. So another way you might ask this question, starting with where Judge Katsas started off the discussion today, is if you accepted all of EPA's fact finding, all of their reasoned decision making, all of their weighing of the factors, and you just took the different language in the preamble about does expect will happen rather than could feasibly, how would this rule look any different? And the answer is it wouldn't at all, because there's no dispute about what available means. So starting from that point, I want to focus my time today on the 3 most important reasons that the court should deny the petitions. First is looking at EPA's overall approach. EPA correctly applied the AIM Act when it looked at availability of substitutes based on a holistic review of all the subfactors.
It's fine to say holistic review, and you don't need to satisfy all of the subfactors, but the building code subfactor seems different in kind. Talking about affordability, cost, efficiency, all of these other factors are questions of degree in which you make a judgment about, at what point does the increase in cost shade into the more expensive option being unavailable. The building code is fundamentally different. It's an on-off switch, and there's no plausible meaning of availability that would apply to something that's legally prohibited. If something is legally prohibited, it can't possibly be available.
That's correct, Your Honor, in the abstract. Certainly, if something is legally prohibited, it's not available. And EPA in the rule found certain substitutes wouldn't be available because they are legally prohibited. But the important thing is forecasting into the future, are they going to be legally prohibited?
So what's your answer? Arbitrary and capricious. So you get, your opponent's running a little bit uphill, but you still have to explain the timeline.
That's correct, Your Honor. And EPA did explain the timeline.
The rule as to HVAC gave a 15-month lead time, give or take, right?
That's not quite correct, Your Honor. So it's...
All right, it's passed in late December 2023, and the effective date, at least for manufacturing and import for HVAC, is beginning of 25.
Right, so that's for manufacturing, 2025, and installation is 2026.
Okay, so I'm not sure which is the more relevant deadline for the industry, but little over a year, a little over 2 years, something like that.
That's correct, Your Honor.
Your own discussion of building codes shows that the states and localities, there's a lag time from when some code is passed and when the legislature updates the code.
That's correct.
And it's 3 to 6 years. It can be up to 8 years. You have a 2023 technical support document that talks about some jurisdictions still following the 2015 codes. That's an 8-year lag.
Yes,
So that seems like a pretty big disconnect between what you anticipate are the lead times to get the codes changed and what you allowed the manufacturers in your rule.
So, Your Honor, I want to have 2 responses to that, focusing on availability writ large, sort of nationwide, and including the experience of the ozone depleting substances phase out, and then specifically what's going on the ground in these localities that might be using longer jurisdictions. So first, on what available for building code means. The AIM Act was not passed in a vacuum. The AIM Act comes on the experience of the Montreal Protocol in phasing out ozone depleting substances. And this exact same process happened there, where building codes originally wouldn't allow you to switch over to HFCs. And it was a gradual process where building codes start out with the international building codes, they start out with the UL standards, and they start out with SNAP approval. Once those things happen, it cascades down. And the reason for that is that industry is pressuring the localities to update their building codes because they want to install their product. So EPA is drawing on that experience. Congress also entrusted them to do that. And they found that when there is regulation, and again, the HVAC sector writ large broadly supports the HVAC requirement because they want everyone to move together. They don't want imports to undercut their ability to sell the updated products. So when you have regulation that allows everyone to move together with one smooth compliance deadline, that is pressuring local building codes to update. And again, no retrofit, no tear old things out. We're talking about prospective. You want to build something new. So that's writ large. When something starts out available in some places, it becomes available in more places over time. And the lag time is not always the full 8 years. Certainly nationwide, we're looking at least 41 states at the time of the final rule that allowed A2Ls. And
Which I had thought pretty much cinched things up for you, but what do you do with Mr. Lynn's point that that's just the statewide floor and they have to deal with Lord knows how many hundreds or thousands of local jurisdictions?
So there's a mixture of the statewide codes, and then there's also local preemption. And again, we're talking about to the extent practicable.
Right.
EPA said they concede it would be totally impractical for EPA to look at every single locality throughout the country. So we're talking about generally available. And there's no evidence in the record, there's certainly no evidence in the comments that they provided during the comment period saying all of these localities and all of these states are going to not have these building codes updated. The vast majority of building codes have all been updated. And this isn't in the record because it happened after the fact, but just to satisfy the court's curiosity, we're down to just 4 states and they're all expected to update by 2025. So what we're
So you
talking
do, sorry.
Go ahead.
Just at the state level, the map looks pretty good for you, but you know, there are three states coded as legislative effort failed.
So yeah, thank you for that question, Your Honor.
What happens in Nevada and Kentucky and Hawaii?
So the legislative effort failed just was talking about the SNAP approval preemption process we detail in our brief, where when EPA approves something for SNAP, it automatically becomes available throughout the whole state. Nevada doesn't have any state building codes. They just have county level building codes. So there was a law passed, or there's a law tried to get passed saying SNAP approval will apply statewide, and that failed. But they're still in the process of updating their building codes in the counties to allow A2Ls. So it goes way too far to say, you know, legislative effort failed means this isn't going to happen. That the record doesn't support that. And what's actually happening on the ground doesn't support that. Then my second point about availability is it's a completely unreasonable interpretation of the statute and what EPA did here to say that EPA has to go locality by locality through all 50 states and check off a box saying now in 2023, available. That's not what the statute says you have to do.
No, I agree with that, but available, I mean, it seems to suggest some congruence between the time in the ordinary course that it would take on average, let's say, to do the updating and the time that you give them. I mean, you know, I suppose you could say, well, if EPA imposes a rule under which states can't have grocery stores unless they change the code, probably they'll change the code, but it doesn't seem like that describes a scenario under which the new standard is available.
Well, again, new grocery stores, Your Honor, going forward. And EPA did say, we have experience from the ozone depleting substances phase out. We saw that it takes a certain amount of time for these codes to be updated, and we expect that to happen here. And so far, EPA's predictions have been correct.
Can I just ask you on the point about general availability? So if it was just true that 5 states don't allow it all, even make them low population states. 5 states don't allow it all, and there's no particular reason to think that they will turn around and allow it for whatever reason. But then 45 states do. Is availability satisfied?
Yes, Your
Because
Honor.
because it's generally available, even if there's no reason to think that in 1/10 of the states, there's going to be a turnaround.
Yes, Your Honor. In that hypothetical scenario, it still would be generally available, but the important premise of EPA's analysis here is slightly different than your hypothetical, which is that when all the other states have it available and adopt it, that does pressure those remaining
Yeah,
states.
there's a hydraulic incentive going on.
Exactly. So that's extremely important
I was
to
just
the
wondering
analysis
about your
here.
interpretive, but the way you interpret the statute is that it's just generally available, meaning available in a mine run of situations, but even if there's a non-trivial share of situations in which it's unavailable and there's no prospect of availability, it's still generally available.
That's correct, Your Honor. But again, going to the facts here, that's why there's a range of substitutes. We're not just talking about A2Ls. We're also talking about carbon dioxide. We're talking about hydrocarbons.
So can I ask, Judge Katsas raised HVACs, and just on that particular example, so the amicus brief says that there's no standing as to HVACs in particular, because if you look at the affidavit, the main affidavit, it's really focusing about refrigerators. Do you have a view on that?
So the United States is not contesting standing for just the challenged subsectors here. Certainly the Guerin Declaration could not provide standing. It just says we're going to be harmed by this rule. That's enough. But the Anderson Declaration does say we're going to incur costs. And that aligns with EPA's analysis that there'll be some startup costs, but eventually
Including with HVAC.
including with HVACs, but eventually there'll be handsome savings from the increased efficiency over time. I mean, all of these new systems are way more efficient than the HFC systems. And that's why, in addition to positive environmental impacts, we're seeing positive cost impacts, especially for small businesses and residences. It does seem the case that they would only be able to challenge standing as far as it affects the food retail industry. But the way the rule is written is just for HVAC writ large. And so assuming you wanted to go down the road of saying just for HVAC, we don't think that that was adequately explained. The remedy would really be remand, and then EPA could craft a more narrow rule. Certainly remand without vacatur, because it's going to be so disruptive to the HVAC industry, which broadly supports this rule, to allow imports from other countries to come in and undercut the new products. So for HVACs in particular, we're not contesting standing, but I think a narrow remedy would be the most appropriate thing there. So one additional point I want to make about the overall approach that EPA said, we had a lot of discussion about severability and what does it mean to knock out something in a Jenga tower? This is not a Jenga tower. This is nowhere close to Ohio. This is nowhere close to Maryland, DC, Delaware, because there you're talking about actual compliance options. FCC, you have 2 options. You can follow this regulation or you can follow this regulation. EPA does not care at all what substitutes the industry decides to use. The market is going to decide what's best for all these different applications. Instead, it's about, is there enough time for the alternatives to come into play and be available? And so once you have that understanding of how the rule works, and this is what Congress said they wanted the rule to look like, then this is how the case makes sense. And EPA, I really want to push strongly against this idea that EPA didn't explain this. It is baked into the rule that you have compliance deadlines into the future so that multiple substitutes can come onto the market, and no guarantee that the substitutes EPA identified will all 100% be available. EPA said this, you can look at the JA 3453, where it talks about there are some substitutes that have constrained availability.
Wait, where are you?
JA 34.
Yeah, I'm on 34.
Yeah.
Where are you on 34?
I don't have the exact quote in front of me, Your Honor, but if you look, I remember from my prep, I think it was in the bottom left side of the 3 columns.
Yeah.
When you look at the rule, some substitutes might have constrained availability, and that's why we have increased some of these compliance deadlines so that everything can come onto the market. That's the whole premise of this rule, is we set reasonable compliance deadlines, industry determines what innovation will happen, and then the market decides what these substitutes are. And they might be different for different, subsectors, different applications. But at the very minimum, I see I'm out of time, Your Honor. At the very minimum, I just want to conclude by saying that for many of these subsectors, I'm talking about standalone units, cold storage, warehouses in particular, The substitutes are already on the market. The transition has already happened. And so vacating those subsectors where there's already widespread availability, it flies in the face of the data, what EPA did here. There are no further questions. The court should deny the
Which one did you say is ready? The cold storage?
So to be clear, there's an available substitute right now in all 5 subsectors, but in standalone units, cold storage warehouses in particular, the substitutes are already dominant on the market, as opposed to something like supermarkets where carbon dioxide is broadly used, Europe, Japan, United States, but it's not dominant in the market yet. Thank you, Your Honor.
Thank you, Counsel. Mr. Lynn, we'll give you the 3 minutes that you requested.
Thank you, Your Honor. Just a couple points. I want to start with a focus on HVAC. I think it's really important to understand there that there are only 2 categories of substitutes, A3s and A2Ls. A2Ls have the building code issue, which I'll address a little bit more. A3s, EPA says themselves that they are only available for window units and portable air conditioners. That is not what we use in giant grocery stores.
Right.
So if you
Rises or falls with the A2.
if you take the A2Ls out, I just don't think you've got available substitutes for HVAC. On the building codes point, my friend gave a long explanation of their experience with the transition from ODS, and he said we saw that the timeline worked. There's one, that discussion is not in the building codes analysis in the TSD or in the rule. And 2, my friend didn't give you years. He didn't say, well, it was 2 years there and it should be 2 years here. And do we know that the state numbers are the same? Do we know that the number of localities is the same? I think you can just point to the ODS transition and say, well, it worked there, it worked here. That's the explanation that's missing. Similarly,
What's wrong with the assertion that it seems that these new standards have been generally approved? Maybe it's 40, maybe it's 30. A lot of approval, a lot of reason to think there will be approval. It seems like jurisdictions respect SNAP and respect the international code. And their catalyst theory, which is this really holds the state or municipal legislators' feet to the fire. Like they're going to get this done because it's important.
of course, Your Honor.
Their towns won't have grocery stores otherwise.
I think one way to think about it is to look at the fact that for some of these, particularly supermarket systems, there was a change in the deadlines after the notice and comment period. So EPA recognized after the notice and comment period that 1 year wasn't enough because of some of the building code stuff. And they had before them this sort of general notion. But then they were like, oh, okay, 1 is definitely not enough. So we'll just add 2 more. We think 2 more is enough. Well, why, right? That's the rational explanation that is missing. And yes, it sort of seems like some of these things are working, but how do you connect that to the timeline? And that's all we're talking about here. It's not the transition itself, but the timeline. They haven't explained that. And on the local building codes, I think Nevada is a really great example. I mean, my friend said there's no statewide building code and the localities all do their own stuff, and that they tried to preempt it and it didn't pass. Well, what's going to happen in Nevada, right? And there's no explanation, even based on experience, as to why this will continue and get any better. Sorry. I had one last point, if I could make it, just on the meaning of availability. We had a discussion about whether they agree to ready to use at the time, or if it's something, I think, significantly more squishy than that. One of the last things my friend said is, we think that some of these substitutes aren't actually going to be available at the time. That's not ready for use. So on the one hand, in his brief, he says, I think it's good that we used ready for use at the time of availability, at the time of compliance, immediately obtainable. And on the other hand, here and in their brief, they're saying, well, when we promulgated this rule, we didn't actually think that all of these substitutes would be available.
I just had one last question, which I forgot to ask you.
Of course, Your Honor.
On standing, I wasn't necessarily persuaded as to cold storage warehouses. The member declaration says we run a chain of supermarkets. I think that gets you the other 4. factors. But my understanding is the cold storage warehouse is something that's not near the supermarket. It's off somewhere else. And I would think it's run by the distributor that sells goods to the supermarket, not by the supermarket.
We have members, Your Honor, that do run cold storage warehouses. To your point,
Well, I mean,
to your point, the declaration did not. The American Frozen Food Institute is an association that includes a lot of members that run cold.
HEB run cold storage warehouses. I know it's not in the record, but
I don't have the answer to that. Sorry, Your Honor, but I'm happy to address that if it is something of concern to you.
Thank you, counsel.
Thank you, Your
Thank you to
Honors.
both counsel. We'll take this case under submission.
Report has been very, Friday, November 13th, 9 a.m.